Here are the 5 partners, with 2 of them being from Croatia, that you may know already, and 1 from Poland. I guess you already have started discussions with these partners, which is a good thing. These are in this project the beneficiary partners. And the 2 from Norway are the expert partners in this EEA and Norway grant-funded projects, with OKP, the host today, as one of those expert partners. The ZEV Hub, the platform, is now available for registration of innovative ideas. As we move forward, we hope that this hub will be an arena for collaboration and innovation, transnationally, of course, between the project countries, which is Croatia, Poland, and Norway, as mentioned. As you can see, the hub consists of many services, and the aim is to support a variety of stakeholders. This is only possible, of course, if we all make a contribution to this platform. So please register your ideas and use this hub as a tool for innovative processes in the future. So just my last slide before I let Emma take us through into the IPR world. As this is a project funded by EEA and Norway grants, there are some goals and milestones that will tick off throughout the project. So in this phase, the main goal is to identify project ideas with the best innovation potential inside or from the ZEVinnovation Hub. That means from your ideas that you put in there. And from there, we shall provide business support and matchmaking services from the expertise partners. And as we are about to do now, we are also gonna deliver training in intellectual property rights and innovation management. If you have any questions to the ZEVinnovation project, or you want to know more about it, you can check out the website. And also our project partner, CTT from Croatia, is also available for questions. So then it's just enjoy the webinar with Emma.
Morning. Morning to all our partners and guests in Poland and Croatia and also in Norway. So today, as part of the ZEVinnovation project, what I want to do is a little piece of training on intellectual property and innovation management. The idea isn't here to give you an overview of intellectual property rights or go into each of the specific rights, such as patent, trademark, design, in detail, but it's to give you an overview of how IP rights arise in the innovation process and how they can be used as tools for protecting and commercializing innovation. So as a start, I want to have a little look about what is innovation, what is invention, and you may have already seen this with Vinco. An invention is an idea, and innovation is when you take that idea, you commercialize it, you make it successful. It might be that you publish a piece of research, you make something known to the community as a whole, or you commercialize it for money. When we think of innovation and invention, we always think of Thomas Edison. That's why we use the light bulb, because Thomas Edison was a prolific inventor. He came up with many, many different inventions, but only a few of them were innovative. Only a few of them were successful, and the light bulb was one of them that revolutionized technology. But I also want to think about it on an organizational level too, in that inventions, they are in the heads of your employees, your consultants. They're where the ideas come from. It's not organisations that come up with inventions and ideas, it's people. So there has to be a process of getting these ideas from your employees out into the world and commercialising them. And that's the innovation process. And IP rights are tools along that innovation process, which help you secure rights, protect them, and commercialise them. And when you look at innovation processes, there always has to be 3 strands to it. When I go out and I usually talk to companies about, IP strategy, people always think, okay, patent, 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 patent. I need to get a patent. But actually, it's not just that. You have to tie all strands together. You can have the best invention in the world and you can patent it. But unless you've got it matches your research and development profile and your commercial strategy, your business strategy for your company, it's not going to be successful. An example, and this was one you might have seen before, is a mousetrap. If you go in to a patent database, you'll see that if you type in mousetrap, you'll get 4,000 results. However, there are only 2 on the market that are really successful. And that's the Tom and Jerry type that we see in the cartoons with a piece of cheese and the box. So patents alone won't secure the commercial success of your product. And it's why any successful innovation and IP strategy needs to be linked to the business and its needs and its strategy. And hopefully this presentation will give you a little look at some tools that you can use for this. Okay, so I want to give you a quick overview of what IP rights can exist in a product. Again, I don't want it to be a technical discussion on each particular intellectual property right. It's just going to be to show you how the different rights can coexist and how different rights can exist in a product. So I always like to take a coffee cup, a thermos cup. Why? Because everyone can relate to it. You can change this if you're in the marine industry with a mechanical piece of equipment, but everyone can relate to a coffee cup. So I want to look at the different kinds of rights that are in there. First of all, everyone thinks, okay, patent, what can I patent? Okay, vacuum technology installation in a thermos cup is a potentially patentable invention. And let me tell you the story of James Dewar. This really should be called a Dewar cup because in 1892, James Dewar came up with a wonderful invention. He worked in a hospital laboratory, and to keep samples warm, he saw that you could use 2 layers of glass with a vacuum in the middle and it would keep them warm longer. However, when he was asked whether he wanted to patent it, he didn't see the commercial opportunity for it and decided not to. So in 1904, along came 2 German brothers and they patented it. And they patented it in the US and they patented it in Germany. And so Thermos LLC was born. So that's one thing you can look at. What potential parts of my product can I patent? What can I possibly use? It might be a component part or it might be a specific element. There's also trademarks to think about. Now, that can be in your brand name, in your logo, in a product name. And it's always great to go out before you go out onto the market to check and register a product name or your logo. So it distinguishes the fact that this is your product, this is what you've brought to the market. It's different from others. So to give you a little example about a trademark, thermos itself as a word was trademarked. At the time, it was distinctive and it distinguished a particular thermos cup, and it was made by the thermos company. However, trademarks can lose their distinctiveness over time, so thermos isn't now a trademark because everybody uses it to describe a particular kind of cup. But it's always worth thinking about how you can protect. The third one is designs. Now, if I wasn't able to patent the technology in the vacuum here, because it's well-known technology, I could look at another way of protecting this product. Okay, how can I do it? I can protect the appearance. So I can protect the appearance of that cup as a registered design. Registered designs they protect the overall appearance of things. They don't protect the technology in it, the solution, the technical solution. They just protect the appearance. And a design would have to be new and different to what else was on the market. Designs are a good alternative if you want to look at protecting a product, because you can protect the product appearance. There are lots of marine companies that register designs for the shape of hulls, for the shape of various parts of vessels. They're quicker, they're a little bit easier to get, and they have a deterrent effect. If your competitor knows that you've registered a design, they're a little less likely to try and copy it. There's an unregistered design right, which is a bit similar to copyright, which arises in certain countries. It doesn't in Norway, but it may in Poland and Croatia. It certainly does in the UK. And that's an automatic design right that protects the intellectual effort in creating a design. But what I want to focus on is the one that everybody forgets, really. And that's know-how and trade secrets. 90% of companies' intellectual property is usually in trade secrets and know-how. And what do I mean by a trade secret? Okay, take Coca-Cola, for example. They could have got a patent for the recipe for Coca-Cola. They didn't do that, because if they'd have patented it, they would have had to have written it in a patent application form and published it to the world. And they would have only had 20 years of protection. So instead, they kept it secret, and it's still, to this day, the best kept product secret, the world's best trade secret, and probably the most valuable. So that's another option. If you don't want a patent, you can keep something secret and limit access to it. And the last one really is know-how. That's what's in the heads of your employees, the expertise that you have, and what you bring to the table. And lastly, there's copyright. In design drawings, user manuals, software, copyright automatically arises in artistic, literary works. So that is another element that protects what you create. So that's a quick overview of how different rights can exist in one product. And it's not unusual for marine equipment to have, say, a thruster, to have many different components which can be protected in different ways. All I want to look at is the innovation life cycle. So, okay, you've told me about different intellectual property rights that can exist in my product. Okay, what do I do with that? I want to look at now at how intellectual property rights interact at various stages of the innovation life cycle. Because a lot of people just think, okay, I've got my product, I've developed it, now I'm going to patent it. Great, go out to the market. But it's not just as simple as sending a patent application or a design application at the end of a process. Intellectual property rights and their importance crop up all through the innovation life cycle. And one good mark of an innovative company is that they have good IP strategies throughout the innovation process. So this circle here is a diagram which is from a relatively new international standard, ISO standard called 56000, and it's on innovation management. It was published in December 2021. It's published for guidance purposes only, so it's not a certified standard. But the idea was that they took experts from the world of IP, from the research institutions, universities, and a lot of large corporations, and they looked at how innovation processes could be standardized. And they developed a set of tools, which are very useful in looking at, okay, how can we have innovation tools and IP management tools? What stages of the cycle do we use them in? And so they split basically the innovation life cycle down into 5 stages: identifying opportunities, creating innovation, validating your ideas, developing them, and then deploying them to the market. And at each stage in that process, IP becomes important. So I just want to take each one of these stages. So if we take the first one, identifying opportunities. So, okay, the innovation life cycle identified in the standards is identify innovation and innovative opportunities. But the IP management task which comes from that is, okay, do I understand the IP landscape that I'm operating in? Do I have freedom to operate? Do I have freedom to develop my idea? And so the goals really at this stage are to understand the landscape, what rights exist before you invest in developing an idea. Is this something that my competitor has already patented? So it's identifying which rights could hinder your development or could block you in the market. But it's also a good goal because it can tell you, okay, what do we have and what don't we have? It helps you to identify what technology is missing or what components are missing. Do we need to buy in or license in software or components here? So this stage is all about landscaping and looking at where your horizons are. And there are a number of ways you can do this, that you can go out before you start the development process. When we look at patents, there are patent databases for both the EU and worldwide. A really good one to use is Espacenet. So you can go into Espacenet and you can type in, okay, I'm looking at code word for keyword for this kind of invention, and it should bring up, you know, inventions in that area with that same equipment. You can also search by competitor. So you can use a software called PatBase as well, or you can use patent agents to do this. When it comes to trademarks and designs, you've got the European Intellectual Property Network, tmdn.org. You can very easily go in there and just type in the logo or the name you want to use for your product, or you can type in the keywords for a design, for example, wax crayon, and it will throw up what designs already exist. Recently, there's been a really good rise in AI software that can also use this. So you've got IP Rally and Cypher that can create searches of patent databases and known journals based on what you put into the search engine. Okay, so what we're looking to develop, what we're thinking of going to, what's nearest to it, and how we think we can move on from it. So those are good resources to use as well. So when we look at when to do these landscape searches, it's always important. As I've said, the worst thing that can happen is you plough a lot of money into research and development and developing your product, only to find out that when you go to an exhibition or you try to launch it on the market, you get a letter from a competitor saying, hey, we've patented this, or we've already got a design for this. So it's really important. It can save a lot of wasted money. So the best stage to do the first landscape search is at the start of development. Now, it may be that you've got a very fast development process, and that will be enough. You can identify, okay, I have room to develop here, and this is where I'm going to go. But sometimes in a development cycle, and especially if you've got a development process where you're looking at mechanical equipment, particularly in the marine industry, it's a slower development process. So from start to finish, it may take 18 months to 2 years. The landscape of existing patents and products might look very different before you launch to when it did when you first started development. So if you've had a long development cycle, it's always a good idea to run that landscape search just before market launch. As I said, there is nothing worse than going out saying, it's 5 days before our launch at the exhibition. Is this okay? And discovering that whilst you were developing it, somebody else patented it. So other tools for identifying opportunities. And this is a little bit as Vinco went into. There are other tools for identifying innovation opportunities. There are business and market intelligence reports, customer surveys and experiences, identifying technology trends, understanding the regulatory framework and how that's going to develop. If you take, for example, the regulatory framework around autonomous vessels, that's a regulatory landscape which is running to catch up with the developments. So second guessing where that's going is building up, is giving speed behind innovation in that area. And also you've got to understand your organisation, where you are and what your resources are. Does the development opportunity fit the organisation's overall business and development strategy? Do we have the skills and expertise to develop this technology? It's great having an idea and knowing what you want to do, but can we get there? So next I want to look at creating concepts. So securing the ownership of ideas. Now this is the fun stage in the innovation process. This is the part of the innovation life cycle when you go out and you stimulate ideas and you source ideas. And you can do this in a number of ways. It could be a design sprint, it could be looking at customer pain points, it can be looking at ideation sessions, it can be looking at product development processes, or it could be that one of your guys in the development team has a eureka moment while he's in the shower. Whatever fits your organisation and whatever methods fit your employees, how it's an individual process, how you get and stimulate ideas. But the corresponding part of the IP management life cycle is, okay, how do we keep a record of these ideas? How do we ensure ownership of the inventions? And how do we maintain confidentiality? So the IP management goals in this phase are to record ideas and ensure you own them. So this is always a pain point for many companies, particularly startup companies and SMEs, when they have hired in consultants or they are using individuals, they're in a collaboration agreements, collaboration projects, because it goes back to this particular point that we discussed at the start. Ideas come from people. So intellectual property is not created by an organisation. It's created by the individuals in it or hired by it. So how do you ensure that that organisation owns it? There are some automatic rules and principles in background law, but these can often give quite different outcomes. They rely on a number of factors. So it's important to look at who is the inventor, identify who came up with the idea, who's been developing this. Is it an employee? Is it a consultant? Is it one of our collaboration partners? And do we have the agreements in place to make sure that we own it before we go out and develop the product and use the IPR in it? Now, this is an overview, a little technical overview of who owns IP rights. And it looks at two situations. It looks at when an employer develops something, and it looks at when a consultant develops something. And you'll see that for the different rights that we discussed at the beginning in relation to the cup, there are different positions. For a consultant, it can change, the position can change varying on what they have created. For software and copyright, there's a presumption that the person paying the consultant will own the results of their work. However, for patents and technical work, the consultant remains the first owner of the results unless there's an agreement otherwise. So unless there's an agreement saying, dear consultant, thank you for developing this for us, we've paid you, now we own it, it's a very grey area. With employees, the answer is a little bit more simple. For patents, the employer will own it if it's created during the course of employment and if it's created as a result of the employee's normal duties. Now, the general specific rules on this will change across various jurisdictions, but for Europe, the general principles that apply are, was it your job? Are you a research person? Are you a developer? Have you hired in a technology and development person? Then you're hired to create things for our company. It's created during your normal work duties, then it belongs to the employer. If it's a registered design, employers will own those registered designs, again, if it's by an employee during the course of their employment. But you can get into all kinds of fantastic arguments, specifically with designs, whether designs were completed during the course of your employment. For example, if I work in a company that makes crayons, but I go home, I use my own computer, I use my own time, and I come up with a design for paintbrushes, is that the course of my employment? So it's always better to have clauses in agreements that specifically deal with this. Copyright in any literary, dramatic, artistic work will all belong to the employer if, again, there's an employee-employer relationship, i.e. there's a contract, and the work was created during the course of employment. With software across different jurisdictions, there are different rules. So there are different presumptions in Norway, as in to England, as who will own the copyright in software that's created if your job is a developer. In Norway, it's a lot clearer. It's the employer. It may be different in Poland and Croatia. When we come to trade secrets, and we discuss the Coca-Cola recipe, so that you can see how important a trade secret could be to your company, there is no automatic legal provision which transfers ownership to an employer. That's why when you're dealing with things that perhaps can't be patented or registered as designs, is treat them as your company's trade secret, but you need an express clause in a contract to transfer ownership. Similarly, databases, if this database is created by an employee, it will belong to the employer if it's joined during the course of employment. So there are some general principles that are out there to help you, but there are always arguments for and against. Did I do this during the course of my employment? Well, I'm employed as a cleaner. I'm not employed as a developer. So it's always best to have clauses in employment contracts which assign rights, including know-how and trade secrets, to the employer. Another good thing to have in there is an obligation for employees to notify you if they have come up with an invention or a design or something that's potentially patentable. And I'm going to go on to why that duty to notify is important in the next part. So with consultants, if there is a clause which transfers all IP created as a result of the employment to you? Check those clauses. Suppliers, okay, if you're buying a normal widget that's an off-the-shelf solution, it's probably likely that the supplier will own the IP to that because it's an interchangeable part. You can buy it anywhere. However, if you have a supplier who is developing something that is bespoke to your products and services, i.e. you as a company are giving them specifications about what you need and you're giving them design drawings, then you want to own that IP in the finished product. So even in supply agreements, it's important to look at, okay, what are they creating for us? Do I have the intellectual property rights in it? And I wanted to talk a little bit about having a notification process and why it's important. In Norway and in Germany, there is in background law provisions that say employees have a duty to notify their employers about any inventions that they come up with, concepts, etc. It's not explicit in UK law. We don't have it. And I don't know what the position is in Poland and Croatia. But why is it important? Why do you want your employees to have an obligation to come forward with their ideas? Again, the aim is to get the ideas from your employees' heads out into the world, protect them and commercialise them. Having a record of those ideas is a really good idea for a number of reasons. The first, if somebody else, a third party, comes to you and says, you infringed our patent, we've developed this. You can say, okay, but I've got a note here that my employee, my developer here, he developed this internally on this date. So actually that was either before your patent or we've got rights to use it because we developed it independently before you got the patent. So it can be a brilliant defensive tool. It can also be a really good tool if employees leave, and it happens. You know, an employee leaves, they go to a competitor, and Bob's your uncle, something else comes on the market that looks pretty much like your product. If you can point to a piece of, you know, a record that says, this invention, this design, here it is, you know, Bob designed it on this date and he registered it with us, then if that employee then goes to a competitor and they start to develop something similar, you have a record if you want to take further action. If it's not patentable, if the invention isn't patentable, it's also a good idea to have a record, because if you choose not to patent it or you choose not to register it as a design, it becomes trade secret or know-how. And how do you have a record of what, you know, if you go into a collaboration project or you're in front of investors, they'll ask, okay, how can you show me what know-how your company has? Oh, wait a minute, I've got this record here. And the last part of why it can be so important, especially for SMEs, is investors. They really like this stuff. If you can go in and you can show potential investors, okay, but we have a proactive process where we record all our know-how and all our ideas. It gives you something that you can show them and they say, oh, yeah, I can see what you've got. It gives you something concrete to show. The second thing I want to look at is in this notification process and the creative process of getting ideas from your employees is incentivization. Now, generally, in European countries, as a result of the European Patent Convention, there's a general principle. And that general principle is one of fairness. And it says, if you as an employer, you obtain the rights to something that your employee has developed, i.e. they've done it during their work time, they've done it as part of their role, and it's within your area of interest, and you as an employer automatically own it, if it becomes a huge commercial success, then fairness dictates you need to share that success with the person that invented it. So that's where you see something called, it's in the UK, it's under the Patents Act, and in Norway, it's under the Arbeidstaker- og Oppfinnelsesloven. I would have a good bet that there is a similar position in Croatia and Poland. There is in Germany, there is in France, and there is in Spain. So what do you do with this? Okay, a lot of employers are frightened of this. Like, oh my God, they can claim if this is important, if this is success, what do we do? It's not a stick necessarily to beat companies with. It can be used as a carrot too. For example, if you have an inventor's reward scheme that many companies do that says, please bring us your ideas. For every idea submitted, we'll give you £50 or €50. If it's something that we want to take further, we want to register it as a patent or a registered design, then we'll give you another amount. If it turns out that the patent application is successful, here's another little payment. And within 5 to 7 years, we'll look at how successful it was and we'll see if we can make a further award to you. Lots of successful companies, large companies, have this process. As the law stands, it only relates to patentable inventions, but you can use it to help your developers come forward with software development ideas. You can use it for designs, brilliant designs. You can't patent it. The background law doesn't apply, but hey, thanks for coming forward with that idea. Here's a little reward. We're going to register it anyway. If people are incentivized to bring ideas forward, they're more likely to do it. So instead of seeing it as a stick to beat companies, it can be used as a very effective tool for getting ideas from your employees' head out into the general organisation. So going back to the next part is validating concepts. So defining a protection strategy. And this is where IP, for a lot of people, gets a little bit complicated. And so I want to have a look at it in the context of innovation management and what ideas and what steps to take. This is the part where, this is the stage, validating concepts, where you do your research, create your business case, define your market and evaluate the idea. And Vinco discussed with you some of the ideas of how you will do this. In terms of the IP management lifecycle, this is the bit where you sit down and you say, okay, what have we got? How can we protect it? What do we do with it? So your IP management goals are to understand whether the invention is patentable, whether it's protectable, can you register it as a design, what are we going to do with it? Decide on that IP strategy, maintain confidentiality, and identify the rights that are required. So deciding on a protection strategy is not a one-size-fits-all operation. It will depend on your organisation, where you are. It will also depend on the product and the market. So if we look at the product protection strategy, what kind of product is it or service? If it's a slow-moving technology area, it's a mechanical piece of equipment, I might want to patent that because it's taken a long time to develop. It's going to be on the market for a long time. It may not be a very fast-moving technology area. So I might decide to patent it. If it's a software application, it's going to be a very fast-moving area. It's very difficult to patent software. You can do it, but it is difficult. Would I want to patent it? Because by the time I've gone through that whole process, 3 years in some cases, technology's moved on. You know, it's a different world to it was when I started out. Plus the fact a patent only covers you for what's described in the patent. If you modify a piece of software or you modify a piece of equipment, or you're likely to, that's not necessarily protected under the patent that you've got. So you have to look at what kind of product is it, what kind of technology area is it, and look at the degree of innovation in it. Is this something that's just like an incremental improvement? It's something that's added on, or it's something that's been speeded up, or here or here or here? Or is it groundbreaking? If it's groundbreaking and there's been a lot of investment in developing it, it's groundbreaking, there's nothing else like it on the market, people are buying it because of the groundbreaking innovation in it, then you should look at protecting it. There's also an idea of, okay, what kind of product is it in the market? Is it a bespoke product, or is it a standard interchangeable product? Is it a widget that everyone else can buy? Not worth protecting it, perhaps. If it's something that's been bespokely developed, it's very special, it distinguishes you from your competitors, then you might want to look at protecting it. And there's the final one for looking at product is adoption and adaptation. So how integral, how important is that invention to the product? So if it's just one small component, is it the key component? And can it be incorporated into other products and services? Can it be adapted? Is there a wider adaptation? So if you've got an invention that's highly likely to be adopted into products and adapted, then you might again want to look at how you protect that. Again, look at the market. Is it a fast-moving technology area? What are my competitors doing? What are their strategies? For example, when the autonomous shipping came out and started to be developed, there was a race to patent various solutions to block others in the market from developing similar solutions. It worked for a couple of years, and then people found solutions to go around it. They found that, you know, the same technology from driverless cars had an application in the marine sector. Organisational factors. How important is this product to our commercial strategy? If it's your key product or key service and it's key to your organisation's whole strategy, then how can you protect it? So again, deciding on a protection strategy, it isn't that one size fits all. Oh, we need to patent, we need to patent, we need to patent. It needs to reflect where your organisation is, the product and the market. So here's often a little thought process that goes through when people are looking at how do we protect, what do we do with this invention? And of course, because patents are the strongest right, the strongest monopoly right, a lot of companies start from that position and they say, is this something that can be patented? Yes or no? Is it new? Is it an inventive leap from what's on the market today? So if we think, yes, it can potentially be patented, yeah, but do we want to patent it? Do we want to write about it in a patent application and publish it to the world? It's a fast-moving technology area. That might not be the best way to protect it. If the answer is yes, and you do want to patent it, then go ahead and instruct a patent agent. Get specialists in, get help. If you don't want to invest in a patent application, there are other ways of protecting it. If you don't want to protect it at all, you could always publish the idea so that your competitors can't patent it. Or you can go back to the position, okay, I don't think it can be patented, or I don't want to patent it, but can I protect it as something else? Can I protect it as a design? Can I protect the copyright in it? Can I protect it as a trade secret? So you might then go into the realm of design protection. Maintain as a trade secret. I'm going to write it down. I'm going to stamp it. Highly confidential. I'm going to restrict access to it. I'm going to use NDAs. If I ever use that information with another party, there's an NDA, and I'll have a secrecy clause in all my employment contracts. So I'll keep that as a trade secret. Or are you going to use copyright? Is it something like software where copyright automatically arises to protect it? Is it content? Is it an artistic work? So there's all these possibilities. And this is kind of a thought process to see, okay, what will we do? So again, deciding on a protection strategy, as we said, it depends on the product, it depends on what it is, it depends on what we want to do with it. So when we've gone through that thought process, we've got some options. Do we want to register it? Do we want to register it firstly as a patent or a design? The advantage of registering IP is that you obtain a monopoly right. For patents, you obtain 20-year monopoly rights to use that patented technology in the country you register it in. With designs, you have 5 years, but you can renew that. In most countries, you can renew design registrations up to 5 times. So potentially, there's a 25-year monopoly period. Trademarks, you have 10 years, and you can renew a trademark registration for as long as you want. So registration can be used to obtain monopoly rights. It can be used to block competitors. It can be used to have robust protection. Most of all, it can have a deterrent effect on competitors. They think, oh, okay, you know, they're very proactive in registering their rights. I think we'll keep away from that. And most importantly, it gives you licensing opportunities. You can go out and commercialise. You can license, you can enter into collaboration projects, you can jointly develop it. You've got those options if you've protected it. The disadvantages, there are disadvantages, and we've gone over a few. With registered rights, with patents, you have a defined scope of protection. If you go and you amend the product or the specification or the software, if it's not exactly as it stood in the patent when you wrote it, it might not be protected. It's geographically limited too. So if you have a patent registration in Norway, you can stop other people developing something similar, but you have to protect it in each country that you want to sell or export it to or market it in. And that, for a lot of SMEs, can be a very costly process. It's something which puts a lot of SMEs off the patenting process because you pay when you write the application, you need an expert to help you write it. You need to pay when you send in the application. There's usually a period of, you know, forward and back between you and the patent office, where the patent office say, no, this is not new, and you say, yes, this is new. So it's a long process, it can be costly, and then you have to renew a patent every year in the country that you've registered it in. And the other thing is designs and patents. When you make an application, the application gets published. So the world will know about what exactly your innovation is and your invention. And it's part of what they call, in Norwegian, the society balance. So you get a monopoly right, but you have to tell the world about your invention. Registered rights, they make it easy to enforce. It's easy to send a letter that says, you've infringed my patent or you've infringed my design right. It's easy to enforce before court than rights which aren't defined, such as a trade secret. So there are, with registration, pros and cons. So what's another option? And this is an option which a lot of research institutions often use when they come up with something. They publish it. Okay. You go out, publish it on an internet or in a journal. Why publish it? It's got a low cost, but it prevents others from registering the same technology or solution. Because if you put in a patent application, first thing that the Patent Office will do is they will look to see if it exists from before, and they will check all publications and they will look to see. And if they find it, they will say it's not new. So if you publish it, it can stop a competitor. It can be used as a promotional activity, and a lot of research institutions and universities, they do that. I've seen it where companies or research institutions have actually published things in the Icelandic Journal of Technology because they publish it in a place where the Patent Office can find it, but actually how many people are going to check the Icelandic Journal of Technology? So disadvantages, it's no prevention, it won't stop others copying it. You've told the world about it, but it'll stop competitors from registering similar rights and stopping you. Trade secret. A trade secret, as we discussed with Coca-Cola, can be a very, very valuable tool. There's no time limitation. That monopoly right on a trade secret doesn't run out. Coca-Cola, since the 30s, have had that recipe. With a trade secret, you get the freedom to define the scope. So you write down what the technology is, the invention, what the trade secret is. And you can use it, that record, as we discussed, to stop others registering something. If they come with a patent registration or they write to you and say, you've copied us, you can say, no, here's my trade secret and I recorded it on this date and this is what it is. But again, it has its disadvantages. Trade secrets rely on companies to be proactive, manage and control access to them, keep them secret, use NDAs, limit access, protect them. They require enforcement. It's harder to enforce them because you probably need to go and chase evidence that how did your competitor get hold of this? But it's important to enforce them. And NDAs and contracts are the way to protect trade secrets. So that's a little in about, okay, how do we protect our intellectual property, and how do we look at what we do with it? And I want to discuss a little bit more about deciding on the protection strategy and how you do it. A lot of smaller companies, they have fewer employees involved in the process. There's a very clear line, okay, who's responsible for making this protection strategy? What should we do with it? Who decides? But in larger companies, it can be great to have an open and transparent process, a decision process, a decision on paper that you can say, dear investor, look how good we are. We've got a decision process around what we do with our IP. And again, when we look back at how you get your invention and you make it relevant to your commercial strategy and your research and development strategy, this is a good point to have in your organisation, this decision-making structure. I've seen it in many different forms in organisations. Usually there's a chair, there's your technology guy or product development and head of product, financial and commercial guy, because they will be paying for whatever protection strategy you choose, if you want to do a patent, etc. And business strategy and sales, does this fit with where we're going? And if you get all those people around the table, it can be a really good decision-making opportunity. What do we do with our IP? It also empowers inventors and developers. I find it a good approach because you can ask an inventor or your employee to come to that meeting, explain and present their idea. It empowers them They get to talk to the decision makers in the organisation, but also the technology guys, the finance commercial guys, they also get an insight into what is happening in the development teams. So it can be an effective tool. And again, it stops silo building and empire building. A lot of companies, you know, who came up with this idea, who decides what to do with it? Well, I came up with it. I'm the product manager. I decide what to do with it. Okay, all right. So at least if you involve the organisation, you can make it relevant to the whole strategy. So, okay, lastly, I want to look at developing concepts and commercialisation part. And in the innovation lifecycle, this is where you're getting prepared for your market launch. This is the exciting bit. For the IP management lifecycle, it's like, how can you development and implement these opportunities? And the goals again are, wow, if we've decided that we're going to register it, where are we going to register it? And looking at commercialisation opportunities. Can we use this in a collaboration agreement? Can we license this? Should we just sell it? So this is, you know, where you've put what you've developed and those tools that you've used into practice. So how and where to protect? If you've gone down the route where you want to take out a patent or a design or register your trademark, the question now is, okay, how widely do we do it? Where are we going with this product or service? So you can either register it on a narrow scope, just for a domestic market, or you can look at it in a wider scope. So if I was just going to protect it on a narrow scope, which a lot of SMEs do for financial constraints, they look at, okay, is this invention nice to have, or is it breakthrough? Is it building on my existing portfolio, or is it something groundbreaking? If it's just something that's nice to have that you've developed, you might use it only in a limited number of products or in a narrow product range. You've got no real plans to further develop it. It was a nice project, but now it's come to an end. It's not strategically important, but you still want to register it because you want to stop your competitor from doing something similar. Then you can think, okay, I'll look at a narrow scope on this. Look at how important it is to my business. Okay, I think I'll just register it in Croatia or in Poland or in Norway. Hopefully, as part of this project, because it's a transnational project about collaboration, you'll look at the inventions that you have and the concepts you develop and say, okay, actually, I want to work transnationally. I want to work on projects where I'll involve people from other countries. I want to develop this further. I need a wider scope. I need to protect wider. So this can be if it's like groundbreaking innovation, if it distinguishes your organisation. Again, it's why people are coming to your organisation. It's central to your business strategy. We've got that high level of adoption into the product. It's a key component. It's the heart of the product, or it's got potential to be adapted into other products. We've invested a lot of money in this and it could be effective. It could be used to block competitors, or I want to go and I want to work with other companies. I want to collaborate with companies in other countries. Then you might want to look, okay, we need a wider scope here. We need to look at where we're going to register it other than in our home country. And so a lot of people ask, okay, we've done this decision making, we've developed our idea or concept, we've decided to patent it, we've decided to register it design. We can see the potential in this. We want to go and work with other parties. How and where do we protect? And this is where you can say, okay, a simple way or factors to take into account when you think, okay, where are we going to protect this, is looking at product, market and competitors. So take, for example, Norway. We have a minister who's come out and said, okay, our focus will be on increasing exports by 50% by 2030. Okay, the only way to be successful at exporting and protecting your products in the countries you export to is to bear this in mind and register and protect them in the countries you export them to. Similarly, if you're in collaboration agreements, where are your partners based? You want to stop competitors in your partner's country or your potential partner, if things go wrong, from developing something in their country. So a good start is the product. Okay, where's my production based? Oh, we're just in Poland. Okay, that's cool. But is there components that are coming in parts of the supply chain from China? Are we sending our design drawings and information and requirements to another country? If so, we should be protecting it there. Where are we going to provide the services from? Where's our supply chain based? What other locations are involved in our manufacturing process? Particularly in the marine industry, it's very common for parts to be produced in different countries, put together in a third country, and then sent and put on board a ship in another country. So look at that chain of which countries. Where do we need to protect this product in that process? You've got the market. Where are we going to sell this? Where are our key markets? Look at it another way. Where can I license this? I don't particularly want to go out and sell this in the US, but it could be a good market for us. We could find a distributor there who could market it and sell it for us. We can license it there. Okay, well, we need to register it there then to protect it and stop others. So look at, those commercial opportunities, which country the markets are in, where your potential collaboration partners are based. You want to sell this, you want to develop a product for vessels in the Adriatic. You want to go out and you want to work with Norwegians and sell them into the Norwegian market. You need to protect those concepts in the Norwegian market. Competitors. Where are your competitors based? And this can be one of the key deciding factors. Where are they based? How are they developing their product? Where are they doing this? So if it's software, I know a lot of software companies automatically protect in Hong Kong, Singapore, China, with their product as just a start off. So it's always key looking at those key areas. Where do we want to protect? And finally, I just want to say a little bit about costs and budgeting, because for SMEs, this is one of the most important questions. Protecting IP, if you register it, costs, and it's something that you have to bear in mind. Drafting or submitting patent applications, that can cost. Design and trademark applications in most countries are a lot cheaper and quicker, and you can almost, in some countries, do them yourself. But you need to factor in the costs of submitting that application, preparing it, and the official fees that go with it. With patents, as I said, there's this forwards and backwards discussion with the Patent Office about whether this is patentable. That costs because your patent agent is involved in that process. So the Patent Office sends them a letter, they respond, and you pay them. And then if you want to go down that phase of, we think we need a wide protection strategy, this is an important invention for us, we need to go out and we need to protect it in the countries we want to export it to and where our competitors are, you're going to have to submit an application in each of those countries. You can use different, and I don't have time to go into it today, it's maybe for another session on which paths you can use, how you register in Europe, etc. But there is a cost of international application. There's application fees, publication fees, grant fees, international office fees, and there's renewal fees. And this is something that a lot of SMEs and smaller companies don't understand. Getting a patent is just the start of it. Every year you have to pay a renewal fee to keep it renewed, to keep your monopoly right. In the first 5 years, those fees are quite nominal. But after 5 years, between 5 and 10 years, they begin to grow because the Patent Office thinks, they've got an invention here that's worth something. They want to protect it longer. So the fees grow exponentially. Similar to design, renew every 5 years, trademark every 10 years. But those are costs which have to be looked at. Now, there are, with the Commission now, there is an SME fund where EU countries and SMEs from EU countries can get help with trademark, patent and design applications. That's available to you and it's a very good resource, but it's still something that you have to take into account. So that's a little overview from me about different IP rights and different parts of the innovation process. I hope it's been a little bit more useful to give you some context on the processes and things you have to think about. And now, any questions?
Yeah, thank you, Emma. Once again, perfect. There, I'm in the frame now. So, if there are any questions now, we have put up some time for a Q&A session, right?
Yep.
So I will just monitor the chat. It's also possible to unmute yourself. We have a link to everyone who's joining us, so that's also a possibility. So,
Hi, Emma. I have one question before maybe other attendees asking in chat. I have one question considering the patent application. So you explained how is it important to have a geographic strategy to know in which country you would like to have a patent. So, but I heard or read that in this year or maybe in the following years, we will have a unitary patent on a EU scale. Unfortunately, Croatia and Spain are currently not within that unitary, let's say, strategy. But can you comment maybe how that's going to be for other countries which are going to be within that system? What are your thoughts? Thank you.
It is, and it's a really interesting development. I think it started about 10 years ago, the idea of a unitary patent court. To give you an overview of what happens now, there's something called the European Patent Convention, and most countries in Europe have signed up to it. It's not based on EU membership, so Norway, Croatia, the UK, they're still part of that convention. And at the moment, you can apply for a European patent through that European Patent Organisation, which is in Munich. And you can send in the application there to get protection in Europe, but it will be treated as a bunch of separate patents. So when it's granted by the EPO in Munich, you then have to decide where you want to validate it. And you have to say, okay, UK, Norway, Denmark, Sweden, Finland, Croatia, Spain. There's where I want to go. And then they send that application onwards to each of those countries. So you get a patent in each of those countries, and you have to pay every year to renew it in each of those countries. And that's how the system works today. What the European Patent Convention will be is much more similar to design or trademark registrations, where there's one single organisation. You send in an application for a trademark or a design to the Madrid system, and you automatically, if it's granted, get a right which covers those 26 countries. It's not a bunch of rights, it's one single right. And you pay one fee for the whole of Europe. And the idea was that we would have this, we would move from this fragmented patent convention, EP patent convention, and we would have a new unitary patent court, which would be for the EU countries. And we will still have that. It will come. Germany have ratified it recently, which was one of the last stages. But unfortunately now the UK won't be part of it. But it should be possible in the next few years to deliver a single patent application to Munich and get a patent which covers all the countries, and you pay one renewal fee. So it's a little bit complicated, but I hope that answers the question, Lovro. It will get easier. The idea is to make it easier for companies to patent across Europe. It will come.
Thank you. Thank you for this answer. Thank you.
See a raised hand. I don't see who it is, but the floor is yours.
Hi, can you hear me?
Yeah.
Mm-hmm.
Hi, it's Vedran. Thank you for interesting presentation. I already have some some inputs from companies to share the presentation later on, and it was really beneficial. I'm just thinking if you would have an advice for companies, let's say, not dealing yet with intellectual property, can you suggest what would be the best, maybe like first 2 or 3 steps you would suggest to them in order to get themselves involved more into managing their IP?
So the first, when you're setting up or you're starting to develop a product, I would make sure that you have your product name, your company name registered, so you can protect your domain names. I would always make sure that if you're developing a product, before you start that phase, to go out and look at the landscape and do that freedom to operate search, see whether you have the room to maneuver, whether you have room to develop. And it's not as complicated as it seems. A lot of people get frightened of intellectual property and IP and think, oh my God, what do I do with this? It's very simple to set up these processes, especially if you're an SME or you're a smaller company, because you can say, okay, at the start of any product development process, we're going to do this search. We're going to go and do a search of the patent registers to see if we've got freedom to operate, tick. What do we need? We need to make sure we've got IP clauses in our contracts. Tick, we've got that. We need to have have we got a form that the inventors can use to send us their ideas? It doesn't have to be a complicated form. And it doesn't have to be, all you have to do is store it in a file that's secure and mark it confidential. So those are very simple processes that can be set up in SMEs at the beginning. And I talk to a lot of companies about this, and one of the biggest things is they just don't know what to do with it. They contact patent agents and lawyers and specialists when they really need to. But a lot of investors getting very interested now about IP strategy. Does your company have an IP strategy? And so if you've got very simple processes in place, like you say, yes, I've registered my trademark, I know that I've got freedom to operate here, I get my employees to send in their ideas and make a record of their ideas, and I keep it in this secure place here, that can really be a good starting point, and it can be something that investors see as really proactive. I hope that answered it, Vedran.
Thank you, Emma.
Yeah, perfect. Thanks.
Is there any more questions? There probably is, but is this the time to bring them up? Emma is.
All questions are good questions. One of the things with IP is it can be very complicated, and people think, oh my God, it's so complex, this is a patent. There's no harm in asking questions. It should be clearer and it should be more understandable for particular SMEs.
No, but that makes me want to say that Emma is a part of the OKP team, so she will be. Yeah, it's not that important if I'm in the frame, but we can go over in here.
Which
on
way?
this side.
Right.
Yeah. So Emma is a part of the OKP team, so she will of course be among the experts mentoring and giving services related to IPR and innovation management as well. So probably not the last time you heard from her. So yeah, but if it's no more questions, thank you for joining in.
And thank you for listening.
Have a nice day.
Thank you. Thank you all.
Thank you. Bye.
Bye.